SJC-12845, Commonwealth v. Kamal D. McCalop.
Good morning, Your Honors. Catherine Oren.
One second,
Sure.
one second. Mr. Keneally is going as fast as he can. Okay, now good morning.
Good morning. Catherine Oren for Kamal McCalop. It's hard to name a greater threat to justice than racist fact-finding in criminal court. It denies the accused trial by impartial fact-finders. It threatens conviction not by proof of guilt beyond reasonable doubt, but by invidious emotion. And it morphs court results, a life-changing form of state action, into equal protection violations. On all scores, this court has rightly stressed need to inquire when facts suggest deliberations possibly exposed to racism. Sole permissible questions establish whether exposure occurred, and if so, neither court nor the public can have reasonable confidence in trial results.
Let's all agree with everything that you just said. That can be addressed on a motion for new trial.
That's right.
On another motion for new trial. I mean, take everything that you've said. It's not like that issue can't be and shouldn't be litigated.
Well, this is what the judge was, when he went back to attempt to litigate the issue, the judge had a very, very bad reaction. So basically, claimed that counsel had engaged in misconduct by violating Moore.
No, I'm just saying your argument is that because of this dynamic, the judge got too involved in the plea, right?
Exactly.
Because the issues you're raising about whether or not there was racism in the jury deliberations, there could be another motion for a new trial that addresses that issue. Your issue is all of that is tied into whether the judge was impermissibly involved in the plea.
Right, but McCalop involuntarily withdrew the racism inquiry under Laguerre, under pressure when he realized that the court had faulted. She had claimed counsel had committed a violation of Moore. And the claim is impossible to understand. Moore proscribes counsel-initiated juror contact without first noticing the state. And the exact opposite here.
But didn't she say during the hearing, no, you had it was fine for you to speak with the jurors? I mean, she made that clear, didn't she?
Well, no, during the hearing, I would ask the court to focus carefully on the court's own Rule 30 findings and rulings, where she does again stress that counsel didn't give notice under Moore, and so there was, in fact, misconduct. But it's not a Moore violation, because two jurors unsolicited approached post-discharge to unburden themselves of shocking conduct.
What should have happened here?
I'm sorry?
I don't mean to be, because I want to cut to the chase here. Let's suppose she got the law right. What should she have done?
Well, she should have, she was put on notice, counsel put court and counsel on notice.
And she didn't believe one of the people. Clearly, she didn't believe the woman at all. Maybe for good reason. I don't know what the reason was, but she certainly sounded like this woman had given her a hard time at trial.
Sure, but she did believe counsel, clearly, enough to prompt a whole lot of drama in court.
Right.
And so counsel swore out an affidavit about the weeping juror on Pemberton. And when the court realized that there was a weeping juror stopping counsel post-discharge on Pemberton, he's asking for contact information. He's putting court and Commonwealth on notice. At that point, everything needed to come to a stop, because second trial verdicts, the only verdicts on the gun indictments, those were purportedly tainted. And so contact information properly issued to both sides of the V, so that inquiry could take place and proper affidavits could be produced for the court, at which point some inquiry could take place to determine whether or not the deliberations were exposed to racism.
But isn't it the defendant's motion to bring, and the defendant, Judge Giles, found knowingly and willingly withdrew that motion in favor of the lesser plea?
That's the thing, is that he withdrew everything under pressure because the court definitely faulted. First of all, was conceitedly working to bring about a specific case
So
disposition
we
by
have,
plea.
we have to find that what the judge did here, her finding of a voluntary waiver was clearly erroneous.
It was mistaken, and it's one of the threats of.
Mistaken, was it clearly erroneous?
It was clearly erroneous. And in fact, it's part of the risks of judges getting involved in plea negotiations. It blinds courts to involuntariness when it's before them. And here, yes,
So I didn't state my first question well enough because I still don't have an answer to it. You're saying everything that happened that you've just describing means that the plea was not knowingly and voluntarily made because of the manner in which the judge got involved.
that's right.
So if that's not true, the plea was to the enhancement. I don't understand why, if there's a serious issue of racial bias in the deliberations, why there couldn't be a separate motion for new trial to address that.
Because he agreed as part of the plea to withdraw the racism inquiry under Laguerre, and that was part of the agreement. And it was not.
You're saying that if this motion for new trial is denied, even though the plea was to the enhancement, and there's a serious question about whether or not the underlying jury verdict was infected by racism, that issue could not be separately litigated in another motion for new trial.
Well, given the record here, where he does withdraw the requested racism
On
query,
the enhancement plea,
right? She's claiming part of what happened
no,
here.
it's not true though, is it?
Right.
It's just not true. I know what she said, but that's
right.
not right.
That's right.
They're separate.
Right, I understand that. And I understand that it may well be procedurally possible. It's just the problem is that he withdrew it as part of the plea
Oh,
agreement.
you know that's not a problem, and you've pointed out in your brief why it isn't, and that the judge wasn't correct.
Sure,
And look-
but once you give away, you at least tell the court that at this point, I'm taking this off the table, and there's no way it could be pursued, really, because you can't get contact information. Nobody could go, on either side of the V, could contact the jurors enough to ask whether racism actually occurred, and if that's all it needs to be established. If deliberations were exposed to racism, that's all that needs to be established. And once he gave it away on the record as part of that plea, I don't see how it's even possible without going through some court process to get the statement he's withdrawing it somehow itself withdrawn,
Okay,
vacated.
Is it possible to withdraw that?
Well,
Any
it's
motion?
involuntary.
Well, people can plead guilty and waive all sorts of rights with a
That's
proper
exactly.
colloquy, correct?
But none
So
of it.
what you're saying, as a matter of law, it was impossible for Judge Giles to get this waiver?
Well, no, it's not a waiver in that waiver is a voluntary relinquishment of known rights, and it wasn't
It was-
voluntary.
She found it was voluntary.
found
You
it was
quibble with that,
voluntary.
and you say we should reverse it because it wasn't, correct?
And that's right, that's right. And for all the reasons that here, these are very dramatic threats to justice. A weeping juror out on Pemberton, and the court reflexively blamed counsel, claiming it was some form of Moore violation. It conceitedly worked to bring about disposition by plea on its account to protect McCalop, basically from his, Your Honor. You have a question?
You should finish. I haven't said anything.
Okay.
I will shortly.
Well, it's impossible to understand the court condemning counsel for violating Moore. All he did was hear them out. He didn't question them, and he didn't get any sworn description of jury events, not without first telling the Commonwealth. And here, all they did, that very court told those jurors that they were allowed to speak post-discharge, and they did no more than accept the court's invitation. And counsel did no more than hear them. There was no Moore violation.
So what are you asking us to do? There seem to be two alternatives. One alternative, which is I think is what you're asking, is that we basically say that the plea was involuntary. We vacate the plea,
Yes.
and then allow you to litigate. I assume you mean before a different judge, maybe not. The motion for the motion claiming that racism tainted the verdict.
That's right,
Okay,
that's
but
right, the
if you,
second trial
if
verdict.
you lose on that, do you agree that the Commonwealth then could seek an ACC2 and seek an 8-year mandatory minimum? Or are you saying that they can't do that?
Well, if it turns out that no exposure to racism occurred, well then, yes. I mean, he would have withdrawn, he would have withdrawn his plea, and he would have all of those stakes open to him. But if the deliberations were exposed to racism, that mandates retrial without any need for
I
full.
understand. But I guess I mean, there are two alternatives. One is basically you throw the dice. You basically say, I'll vacate the deal that I got, and
Right.
I'll take my chances on the motion for new trial. And if I lose that, then I may face the prospect of an 8-year mandatory minimum. Or are you saying, as Justice Lowy may have asked, I don't know whether he did precisely, but to say, no, you're not challenging the plea, but you want to be freed from the waiver of your pursuit of a motion for new trial, and you want now to pursue a motion for new trial based only on the racism claim, and if you lose that, then the plea will stand.
So that's the question I wanted to ask. Exactly that.
Well, no, everything is properly withdrawn. All the plea, everything, because it's all the product of potential racism. We have every reason to think that a weeping juror, they reduced that lady to tears outside here, that this happened. If that happened, everything goes away. So he wants to be clear of this.
Right, I
Any effect-
understand, but the difference is that under scenario 1, you are facing a possible 8-year mandatory minimum if you get what you want. Under alternative 2, you'd be facing only the very same sentence of a 4 to 5. That's why I'm asking you what you want.
Right, but it would be an enhancement, though, of verdicts that were returned by purportedly racist jurors. So he wouldn't want any sanctions at all. He would want everything off, and he would be rolling the dice, so to speak, if that, the way you say that.
The point is, he would start again, and
Yes.
again means he could be exposed to minimum mandatory of 8 years.
He could be.
And he's okay with that.
Right, but
But did you hear the chief was giving you another option that would be better for him?
Well, behind door number 3 is.
No, it's door number 2.
Yeah, no, it's door number 2, I get it.
well, that he accept blame on for part of it, even though the underlying indictments, the verdicts, were returned by purportedly racist jurors. He wouldn't accept
Right, well,
that.
certainly,
And I
if
think that's
certainly if he were to prevail on the motion for new trial, the plea would go away,
It would go away.
obviously.
Right, but the whole point under Laguerre, the motion for a new trial would work if the colloquy reveals that, yes, the deliberations were exposed to racism. Everything goes
He
away.
get a new trial. Certainly, he would, if you prevailed in that argument, which I don't know whether or not you would, because all we have is the affidavit right now.
Right,
Okay.
that's right. And so you basically, the findings and rulings here, and I would ask the court to focus on the court's own findings and rulings. They realize threats to voluntariness stressed in our case law, cases like Johnson and Damiano and Gordon. The court controls process and sanctions. It was no less than the final arbiter of Kamal McCalop's
Why
fate.
isn't, Justice Gaziano was mentioning how we, absent clearly erroneous, we're accepting Judge Giles' findings. Why isn't what she's doing, in this case, trying to save the defendant 3 years in prison, but she doesn't want to do it unless he's really knowingly and willingly giving up certain rights, and when she, Judge Giles presents this to the defense lawyer, he practically leaps out of his seat saying, yes, absolutely, we'd like to have that offer again.
Well, he's alarmed because she does repeatedly, you're not supposed to be talking to her. You've upset the apple cart, you're not supposed to be talking to her. And he's so knocked back on his heels, he offers repeated factual defenses to any suggested Moore or Fiddler offenses. So she's not trying to save him. It's not her job to save defense from his own counsel. And they made a very specific determination based on dramatic events out on Pemberton that signal under case law. That's a bright line issue. If it happened, everything has to be redone.
She also knocked the Commonwealth around and got them to put the deal back on the table, right?
I'm sorry?
She also knocked the Commonwealth around and told them to talk to your bosses and get this deal back on the table.
Right, but that's a deal on purportedly tainted verdicts. And we have every reason to think that going back and doing it, the first jury hung. We have proof of guilt so infirm that it hung a first jury. The only we have one juror reduced to tears on Pemberton after the only jury that actually found guilt on these gun indictments, and it's pretty attenuated constructive possession evidence. And so what he's keen to do, if this is the product of racism, that can't stand. He wants to contest it. But the risk of thwarting plain court-desired disposition, that's a known threat. It scares people into self-conviction because they are reasonably concerned about sentencing differences if they insist on trial rights. And she faulted counsel for a non-existent moral violation. She claimed Laguerre inquiry was off limits, so it wouldn't work anyway. And if he wanted to try it, any demanded trial had to happen that week, even though counsel couldn't be there. So there was quite a bit more than the judge simply saying, if you go to trial on this, your sentences are going to be dramatically enhanced. She faulted counsel. She purported sole grounds for Laguerre inquiry. That's the fruit of counsel misconduct. It's not going anywhere. And if you want to do it, you got to do it now, whether or not your lawyer is there.
I'm going to ask I'm going to try the question the third way now, because I'm still not getting an answer to it. What is your view? If we find that the plea was being made knowingly, willingly, and voluntarily, can your client, on the enhancement, plea to the enhancement, can your client still bring a motion for new trial on the underlying verdict saying that it was tainted by racism?
I believe so. We're going to run into a wall because he gave away his rights on the record, and this is what I'm keen to do through the court. He didn't give his rights away. He was scared into it.
Thank you.
Thank you.
Ms. Knight.
Good morning, Your Honors, and may it please the Court, Erin Knight on behalf of the Commonwealth. I will actually start with Justice Lowy's question. In fact, he could still raise this in a motion for new trial and a secondary motion for new trial, and the Commonwealth would actually invite that. We would not challenge that claim as waived at this point because.
Would you also not, if he won them? I hate to put you on the spot here, but I'm afraid I'm going to. Would you also be willing to say that if he does challenge and gets a new trial, that you wouldn't seek more than a 4 to 5 if it's denied?
Unfortunately, I am not allowed to give you the answer to that. That's, again, I'd have to go back to my superiors, as the Commonwealth had to do in this case. So unfortunately, I cannot answer that. But what I can tell you is, the Commonwealth also has a substantial interest in a jury free from bias. Our interests are aligned in that respect, and we would actually welcome if the defendant walked out of court today and wanted to file that motion for new trial. We would welcome that because it is a serious inquiry that may need to be made. However, what we are here for today is based on the involuntariness of the plea and the judge's actions during the sentencing hearing. And I would say the colloquy truly counters the defendant's claims here. And I would also point to the judge's decision on the motion for new trial that explained what she said, explained what she did, explained that he still can bring his underlying inquiry claim via a motion for new trial, a separate motion for new trial. And I think what's really important to point out is that what he withdrew at this sentencing hearing was actually a motion for contact, or a motion for juror names and contact information. I don't see it as him foreclosing the inquiry in its entirety. So in fact, I do believe that and we would welcome a motion for new trial on that underlying claim following the hearing.
Where did Judge Giles say that the defendant could still bring a motion for new trial based on the claim of racism? I
She says that, and if you would just give me 1 minute to find the exact page number. It's Record Appendix 117, her decision, page 10. She states that The mistrial motion was improper because the verdict had been taken, and that she goes on to say that on page 11 of her decision and the record appendix 118 top, she goes on to say that he was obligated to pursue his motion to inquire about alleged juror bias through post-verdict practice, not a motion for mistrial. I never forbade Attorney Malcolm from pursuing this inquiry, explaining that I could not entertain his motion for disclosure of jurors' names and contact information right now, but I'll hear argument on it. So I would say that that implies that it would be proper for a motion for new trial. Whether or not she was saying he can still bring that, the Commonwealth argues that that's besides the point, because we're here saying that we would not treat that claim as waived should he pursue it.
Okay, so, I mean, part of the deal was that that motion be withdrawn.
The motion for juror names and contact information, yes. I do not view that as a motion for closing the inquiry in its entirety.
But if that were to be, if this defendant were to say, I move for new trial and I need this information to explore whether or not this verdict was tainted based on paragraphs 10 and 11 of the affidavit of Mr. Malcolm,
Sure.
you would not oppose that?
No, I don't think we would. For him to inquire himself, he would obviously need that information. He also, in a different manner, could have asked the judge to inquire. There are many different ways to get about that information, but I think the main point to be made is that the actual underlying inquiry has not been foreclosed, and the Commonwealth does not treat it as such.
Okay, what do we do with, how is this defense counsel supposed to be there when he says, I can't be there, and she insists that the case be tried that week?
Absolutely. So there was some back and forth about dates and counsel not being available, the judge not being available the week following. But I think what it really boils down to is if he was to pursue and continue, she made it clear that, as you can see, the Commonwealth has the ability to take that plea back. You've already told us, and it's in the transcript, right when he walks in, defense counsel says, we really do want this plea. We're encouraged by this reduction in sentence. And I think it's made clear that while she doesn't say, all right, stop, let's find a date 3 weeks from now, she does say, I think the plea, she makes it clear that the plea probably has to go forward today if he wants that sentence. And that's not improper. What she's explaining to him is the reality of the situation, and I would argue that looking at the colloquy, looking at what happens just before the colloquy, he's given time to consult with counsel. He's given time to consider what would need to be done to obtain that favorable plea, and it's a very favorable plea that he's given, and he makes note of that in his colloquy. Defense counsel says that he's grateful for the Commonwealth's concession in that area, and I think that looking at the colloquy and how many times the judge inquired as to, you're waiving this right, you're waiving this right, he answers yes to everything. And so I think if you look at it, the colloquy itself, separate and apart from the dates earlier, I think that's really almost a red herring, because while he could have pressed for a further date. He absolutely could have. He could have said, no, we are going forward on trial. He instead chose to take that plea. So I think that the date thing, while the judge could have stopped and said, okay, we need to find a date that you can go forward on trial, or go forward with this motion, he didn't choose to do either. He chose to take the plea, which he knew meant not going forward.
I was just going to observe before that, it looked to me like the trial prosecutor was basically in a snit. And that the judge was doing this to smooth the prosecutorial feathers. Apparently, Mr. Malcolm had really aggravated the prosecutor, and that when Mr. Malcolm brought this motion regarding juror allegations of racial bias, that's when the prosecutor decided to take the plea off the table. That was pretty poor form, don't you think?
So I want to make clear that the prosecutor didn't take the plea off the table. What had happened was the motion had come before him. He had sent it up to his supervisors, who were like, oh, we need to look at this. We need to consider this if this is going to go forward, in light of if he's going to pursue this motion, there isn't going to be a plea right now because he needs to pursue the motion. So I think a better characterization, respectfully, Your Honor, of what was happening was the Commonwealth had brought the information that the motions were filed to his superiors. So his superiors were like, wait, we need to figure this out first. Once we figure that out, then we can move forward. Instead, what the judge said, to the prosecutor was, okay, so I realize now that the plea may be in limbo here because of these motions. If he were to withdraw those motions because he's made it clear that he is, favorable to this plea, these terms of this plea, if those motions are to be withdrawn, would your superiors then allow that to be back on the table? Can you make a phone call? He made that phone call, and the answer was yes.
Okay, that's another way of looking
And I
at
guess
this.
let
Thank
me,
you.
let me explore that. I mean, this was a different DA. This was the previous DA.
Under the previous day, yes, Your
Okay.
Honor.
If this happens today, under your DA, is it appropriate for the Commonwealth to withdraw a plea offer to avoid an inquiry into a claim that the verdict was tainted by racism?
Again, I don't think it was a withdrawal of the plea offer in so much as the word withdrawal. It was we need to look at what's going on here.
Apart from what would happen.
Sure, sure.
Is it appropriate today for that to
Yes,
be?
so under our current DA, I know that this would be something that she herself would want to hear about, and it would be run up to her herself. She's very cognizant of these issues, and as I said, we have been talking this case over and came to the conclusion that I explained to Judge Lowy earlier of, we welcome the motion for new trial to look into this a little bit more. She's very cognizant of that issue, and the Commonwealth, again, we have those interests are aligned, and I think, maybe while this didn't go that way during this particular hearing, I'm not sure that the prosecutor at that time had any sort of, duty to press it for the defendant, I guess, at that point. Not saying that that wouldn't be the case now, that our DA may allow or may push for more inquiry into that type of possibility, and maybe she'll take that from this argument. But at that time, it was not withdrawn. It was just, we need to figure out what's really going on here.
And what is the obligation of the court?
In this instance,
Yeah, when a court has information that the attorney says he spoke to a sitting juror, put aside the alternate juror,
sure.
and that the person says she was surprised to see the amount of racism expressed and vocalized during the deliberations by several of the jurors, and that she felt that the racism changed some of the votes to guilty. What's a judge's obligation?
So I think at that point, we can go to those cases such as Laguerre and McCowan, and when those issues are raised, I think if you look at especially those two cases, those are cases where there was an affidavit alleging actual statements had been made that the judge could then take into consideration and weigh. Here, while, again, the Commonwealth agrees that this is a serious issue that needs to be looked into, there's no specificity. So while the motions were withdrawn, the judge didn't need to make a decision and didn't possibly get to that point, it would be viewed in an abuse of discretion. And I think at that point, we would be here arguing about possibly a very different situation.
If you look at the entire hearing, I may be wrong, but I think that part of what the defendant is saying is that the judge got too involved in the plea negotiations. And one of the reasons was, the weakness of the argument as it related to what the juror had said, and also that was an issue that was going to have to be addressed. And I think that perhaps the Commonwealth's position, I guess I'm going to ask you this, or at least Judge Giles' decision is, no, I was trying to have him do 3 or 4 years less in prison. What can you tell us, looking at the 4 corners of the transcript and the motion for new trial, which way we should look at that?
Sure, and I will point to the judge's decision on the motion. She does take the defendant's, the defendant's issues with certain statements head on and explains her thinking. So I would point the court to that for Judge Giles' thinking. As far as the 4 corners of the transcript show, she did say, good going, Mr. Malcolm, you've upset this apple cart. But she also said things like, I don't want anyone to feel pressured. I'm the neutral here. In reality, when she told him you're facing a maximum of 8 years, That's just the truth. That's the fact. That's not something under, say, Damiano, where it's a, I'm going to give you more if you don't plea. That's not the situation we had here. She just wanted the defendant to really understand what was going to happen should he lose out on this plea. He was going to face a much more severe, possibly a much more severe sentence. You know, I think this court is probably fairly familiar with ACC pleas. It's not a high burden to prove. So I think that she wanted him to really take that into consideration, especially in light of when defense counsel first walked in, he said, you know, the Commonwealth has offered me this and we're interested in that. And he again, after speaking with his client, reiterated to the court that he was very grateful for the 4 to 5 instead of the minimum of 8, which again is a discretionary minimum, or is a mandatory minimum of 8, but a discretionary sentence. So it could have even been more than that. If there are particular instances in the transcript that you're also concerned with, I'm happy to answer that. But I think overall, if you look at what happened, the context of what happened, and along with her decision on her motion for new trial, which I really think she tries to suss out what happened and explain in her own words what she was thinking, just goes to show that she was trying to warn him that, you know, this is impending if you continue, and that's not improper. It's a fact. And if the defendant sees that as a threat, then, you know, that doesn't really make any sense because it's a minimum mandatory, and his counsel, it's assumed, would have explained as such to him.
I have one more question.
Sure.
During the discussion, the ADA appeared to be teed off because there was, defense counsel was arguing that the gun may have been planted. And he said, you know, how can you possibly make that argument when the gun was registered to a relative? And then I read your statement of the facts, and there's no reference to the gun being registered to a relative. Was that in evidence?
Not from my recollection, Your Honor. I think that might have been like an offhanded comment. I don't believe the judge took that into account in any event, but not from my recollection. I'm happy to submit a 16L if you'd like me to.
I'm sure it's sufficiently related, but it's just sort of weird that he's basically saying that this is, that the gun was registered to a relative, which would seem to be a probative fact in this particular case, and I didn't see it in your statement of facts.
Sure, and I don't particularly recall that from
It may not have been admissible in evidence, though, right, that fact?
Exactly. Tensions were high here. There were back and forth between the defendant, some of his a relative that was in the audience, and the prosecutor was noticeably flustered. Judge Giles noticed that too. If I may just finish my thought. But again, this plea was very favorable to the defendant, and that's what the judge was trying to make clear, and I think that's where this court has to come down on. The issue is the involuntariness of the plea issue and not the underlying claims.
Okay, thank you.
Thank you.